Hello folks and welcome back to True Crime Phenomenon. This is Josh coming back to you with another video. This is the final video in the series of Jeremy Dewitte's bond hearing, part 7. I just want to say thank you to all of my subscribers, especially those of you that have been with me since pretty much day one. People like Leonard Hill, Marion Headland, Char Elder, Music Man 10, Pyro Falcon, Sticky Fingers. Oh man. Let's see, Gia, Wendy Markham. I mean, there's just so many. I can't even. I can't thank everybody in every video, but I just want to say thank you so much, guys. I really appreciate all the support. The channel's growing so fast. I'm at a loss for words. So thank you so much for watching. Please like, share, comment, and subscribe. Most importantly, comment down below. You all know I love to interact in the comments with you guys as much as possible. I'm getting too many comments now to where I'm having a harder time keeping up with the replies. But if you leave me an original comment, I will read it. I read all of them. So thank you so much. Please like, share, comment, subscribe. And don't forget, YouTube does remove comments sometimes too. So if your comment's not there, it's probably because YouTube removed it. All right. Thank you so much, and I'll catch you on the other side.
The only thing that he really had that was legitimately there was probably the tourniquet and the gun.
Okay.
Oh, and I believe he had flashlights too. Two flashlights.
So an arrest is made based off of an assumption that he's carrying a weapon that turned out to be false, correct?
No, arrest was made because he was stopped. From what I understand, he was thought to be one of the Metro State employees because he was not wearing a uniform that he normally would wear. Because of the stop for openly carrying a firearm, we know that he's not a security company. He never has been a security company, so nobody in his employ dressed in his uniforms can be out openly carrying. And they didn't have fishing poles with them, and they didn't look like they were going hunting. So he was stopped for that purpose. After it was determined that it was not a firearm, it was determined that it was a pepper ball gun, he was charged with carrying a concealed weapon by a convicted felon. Because you could not tell it, even once you took it out of the holster until you went to clear it by dropping the magazine or racking it, that's concealment. If you cannot tell it what it is, that the average person on the street cannot tell what it is, it's a weapon or a firearm, that's concealed.
Okay. I appreciate you trying to justify the arrest that was dropped.
I'm not justifying. You asked why the arrest was made. I just told you I'm not justifying anything. I wasn't there to make the arrest.
Okay. What illegal item amongst the half a dozen or more things that you just rattled off did Mr. Dewitte that he's not permitted to possess?
Say again?
What was on that utility belt of all the things you listed that Mr. Dewitte is not permitted to possess?
Not permitted to discuss?
Possess. Yes, Your Honor. I'm sorry. These masks are awful. I apologize.
That's okay.
Well, for example, he had the pepper spray. If he had the pepper spray in his pocket, that would be a felony for him.
I'm not asking hypotheticals.
You're asking me kind of like a trick question. Okay.
Of the items that were taken from his utility belt that you just described in detail, which of those is he not permitted to possess in the manner that he possessed it at the time of his arrest?
Okay, that makes sense. I'm sorry. The weapon that he had, the weapon that resembled a firearm.
And what Florida statute was he violating by possessing that weapon?
Carrying a concealed weapon by a convicted felon.
Okay. You're calling it concealed. I'm sorry. I didn't mean to talk over you.
I'm sorry. I believe that's what he was charged with.
So the weapon that's on the utility belt on the outside of his person, you're saying was concealed?
Is what?
The pepper ball that was on the utility belt on the outside of his person, you're indicating was the concealed weapon.
It was concealed to the point that the law doesn't say it has to be completely concealed. There's case law that supports that. In this case, it was concealed to the point where you could not tell what it is. It looked like a firearm. Anybody who saw it, whether you be law enforcement for 50 years or a civilian walking down the street, would think it was a firearm. And then when you put that into totality of his uniform and everything else that he was wearing and riding with all the lights, it gave the full impression that it was a firearm.
I understand that's your opinion. I'm trying to understand what the statute is that you're referencing. Do you know what the statute is?
Do I know the number? No, I don't know the number offhand.
All right, but it's the carry and conceal weapon statute.
Yeah, by a convicted felon.
Okay. All right, I don't have any further questions. Thank you for the indulgence, Your Honor. I appreciate it.
Okay. May this witness stand down now?
Yes, Your Honor.
Thank you, Deputy.
Thank you, ma'am. My wife will thank you, too.
Pardon me?
So my wife will thank you, too, because we were supposed to go camping, so we held up a little bit. I appreciate it. Thank you.
Yeah. I can understand why she would thank me. Call your next witness.
No further witnesses, Your Honor.
Okay. Does the defense wish to call any witnesses?
No, Your Honor.
Okay. So this is the defendant's motion for a bond, and I'll hear your argument.
Yes, Your Honor. May I argue from counsel table?
Yeah.
Your Honor, as the motion indicates that all of these cases were cases where Mr. Dewitte was either out on bond or ROR by Your Honor for pending criminal charges, including some of those that were presented piecemeal to the court today. It wasn't until his arrest in this, what was originally coined a domestic violence arrest, which precipitated a victim hold being placed on Mr. Dewitte, and then him appearing for the IA the next day, that Judge Bain revoked all of the bonds and RORs, causing Mr. Dewitte to be incarcerated since that time. Mr. Dewitte has been fully cooperative with me as it relates to keeping in contact with me. He has what was at one point a viable business that still is ongoing, albeit struggling without his direct involvement. He has substantial ties to the community, including his wife and child, all of his family. He's never failed to appear before, even in circumstances when he's known that there may be a warrant for his arrest, and he has voluntarily surrendered himself multiple times when he's been found to have a new warrant. He is not a flight risk.
Well, he had those lovely RORs on all those capuses. Yeah.
He's not a flight risk, Your Honor. He's never been shown to be a flight risk. There's nothing of record to suggest that he is. He was very candid with the court about what he did 20 plus years ago in reference to the passport issue. That is not any kind of current concern or constraint that he would have any issues with. So there really isn't an issue of flight risk. I think that the focus of the state's presentation seems to be the danger of the community argument, which according to their own testimony, they're saying is still ongoing while Mr. Dewitte is incarcerated. So I suppose their argument's going to be the Metro State as an entity does business in a manner that they feel endangers the community, but I don't know that that's something that should be impugned on my client. What Your Honor is not seeing, and what exists in the real world are thousands and thousands and thousands of funeral escorts that have zero problems whatsoever, that have zero incidents of any kind. We have a track record of years and years of providing these funeral escorts without issue. Mr. Dewitte is not.
So that wasn't him on the video screaming at those people and using profanity repeatedly and directing people off the road? That wasn't him?
That's not what I'm saying.
Oh, I'm sorry, because that's not a legal analysis. Because he has had so many days of doing such wonderful legal activity that the illegal activity he committed on a particular date shouldn't count.
That's not what I mean to imply.
Okay, well, that's what I got out of that.
Well, let me do a better job.
Okay. Good.
The fact that there are incidents that are before the court that Mr. This is a business that provides a service and has, at one point, quite a few funeral homes and organizations that utilize them for these escorts without incident. So my point is not that in some way negates what the court saw, but that Mr. Dewitte is fully capable of exercising good judgment and operating in an appropriate way.
Good, because I really do not want to see weeping former customers talking about what a grand and helpful person he was when their loved one passed.
And that's never happened.
Good.
So the issue here, Your Honor, is really a matter of whether Mr. Dewitte can be given appropriate constraints while out in the public so that there is not an ongoing concern for the safety and welfare of the greater community. And I think that the court has every ability to do that. Mr. Dewitte will comply with those constraints, and if he fails to comply with those constraints, he understands where that's in the land. So we'd be asking that bonds be reinstated. I understand that that's a bit unorthodox where the bonds have already been discharged, but the bondsman is willing to rewrite them.
No, it happens.
And the purpose of that, with all due candor to the court and to the state, is Mr. Dewitte is suffering financially, and so bonds of some large amount is guaranteed that he's going to be sitting in jail. And for what it's worth, I'm sure the court could care less about my financial involvement with Mr. Dewitte.
That's correct.
That he doesn't have the financial wherewithal to post large bonds.
Understood.
And so we would ask the court to reimpose the bond originally said. If the RORs are not sufficient for the court to feel there's some kind of safeguard to be released on pretrial release, if GPS monitor is something that the court wishes to impose, Mr. Dewitte indicates that he is more than willing to comply with that. If there's any other special conditions that the court wishes to impose, he's also willing to comply with that.
What? Did you mention the testimony about threats to law enforcement officers, threats of violence to law enforcement?
No, I asked, there was a bulletin put out claiming that my client was going to go in and commit suicide by cop, and so I had asked
if he ever actually heard that.
Right. The only source of that information was a conversation somebody had apparently with Vince Perkins. We've got countless audio and video recordings, and not once did my client ever utter this.
So that witness's testimony was just not credible. That's what you're asking the court to find, insofar as that's concerned.
Absolutely. I mean, and not to
that's fine. That's a legitimate position to
not
take.
to mention my client's here 2 years after this supposed bulletin went out, has been confronted by law enforcement officers in the last 2 years, God knows how many times, and has not lifted a hand, let alone ever feigned some, shootout at the OK Corral. So that's just nonsensical. There's no evidence of this. He is not a threat to law enforcement. So we'd be asking for this bond to be reinstated.
Understood. Mr. Moore?
Yes, Your Honor, this really is kind of the first time a court has been able to look at all of these cases. When Mr. Dewitte is rearrested. There, what
Not
makes it
rearrested, arrested.
correct, and
He hasn't been rearrested until at all on the charges for which he's now seeking bond. He was only arrested once. He was ROR'd. Then he was arrested on a domestic violence charge. And at IA's, his bond was revoked. That wasn't an arrest.
I wish it was that simple. there really is a long history to this because it dates back to that first Windermere case. That happened on September 7th of 2019.
So you're saying he was arrested on, let's say, that charge before this court signed capias on him?
No, that was the first arrest on September 7th of 2019.
I can't wait to hear how he's been rearrested. Not to split hairs, but arrested on different charges, yes. Okay, that's not a rearrest. That's another arrest.
Correct. The DV case that Your Honor is faced with today that happened on April 7th, and now there's a new warrant which Your Honor has, which is the failure to report case from Osceola County. That was served on him a couple weeks ago. Those are the 5th and 6th new cases that happened from criminality that would have occurred after the initial. So my point being, he has come before courts on several cases with new criminal charges, not things that preceded. He has also come before the court with several cases that preceded that original arrest, and that's what really constitutes the 12 total cases between Orange and Osceola County.
Why wasn't his bond revoked until Baines revoked it on the DV?
Your Honor, there is actually still pending motions to revoke bonds that the state filed back in February on some cases that were just never heard.
Why?
Because there was so much confusion at the IAs about when things happened, and judges would get flustered with what's going on. Well, I'll let that. I was personally covering this case for Mr. Miller here in Orange County. It was supposed to be for PTC, and Mr. Dewitte had just gotten arrested in Osceola County for that failure to report. And Judge Barber did not want. I asked her to revoke the bonds, and she said, "I'm not going to take that action today." And then nothing happened.
For conduct that occurred after he was arrested on that Windermere 2019.
Yes.
Okay.
Yes. And I can detail each case how that happens if Your Honor wants. But that's what's been kind of the confusion in all of this. And I don't know.
That wasn't really made clear because the court didn't understand that from the evidence, but the court did understand that there was a DV arrest. That's, there's been an attempt to unwind that and turned it into a foot slammed in a door. And then there was the failure to register arrest for conduct that occurred after
yes,
these events.
the failure to report cases, while they are different in nature from the personating officer cases, they still fit in this category of deceptive practices that Mr. Dewitte engages in.
Why do you feel that you have to respond to that? I mean, doesn't the law say that if someone is arrested while they're out on bond, the court has the discretion to leave them on a no bond status when the bond's revoked?
That's correct.
It doesn't matter what kind of case it is.
Right, and I think that's what's been
So
argued.
why are you making that argument already? Why are you saying that? It's the same type of case.
Well, I just mean to say I think some judges maybe were RORing thinking that these were not significant cases. And when we talked at the bench, you had mentioned these are nonviolent cases, and I did want to make sure that this court was aware, because like I said, I don't think many courts before have had a chance to at least experience what is going on in these processions, these funeral processions, that these aren't necessarily nonviolent cases. They do involve some serious behavior that is concerning.
I think counsel completely misinterprets and misreads this court. So.
Well, Your Honor, I am asking you to keep him no bond because of the new arrests, of course. That's first and foremost. Mm-hmm. If Your Honor was thinking of releasing him, I was presenting to the court evidence that I believe his behavior and conduct is dangerous in the community. There has now been evidence of other types of dangerous threats in terms of, potentially causing harm or making threats to witnesses. Mm-hmm. And based on those things, I do think it's still appropriate to hold him no bond until we can get these cases heard and resolved.
Counsel, the failure to register case is going to be tried next week, and it may be tried by this court.
It's on the docket next week, Your Honor. Right.
And is the state prepared to go forward and prove that case?
We can, Your Honor, yes.
So that's a yes?
Yes.
Okay. Because there are 4 cases that have been assigned to this court, so we're not quite sure yet which one will go.
Yes.
Is there a minimum mandatory on that charge? I believe there is, isn't there? Failure to register?
No, the failure to register.
So what is this charge? Failure
to register as a sex offender. So he has 1 initial count and then 2 more registrations where he still omitted to register a vehicle that belonged to his wife. So
no minimum mandatory?
Not on a failure to register, no, but he does. I think I don't have the score sheet in front of me, but there's a minimum guideline sentence, and then we did also file a habitual felony offender notice in that case, as well as all of his others.
Okay. Anything else?
No, Your Honor.
Okay. Counsel?
Your Honor, the crux of our argument is this. The courts have heard, every time Mr. Dewitte's been arrested, arguments from the state that his bond should be revoked, and they have declined to do so for whatever their individual reasons and rationales were. Of the arrests that have happened subsequently, one was what we believe to be an unlawful arrest in March that the Sheriff's Office Legal Department unarrested my client the very next day prior to the initial appearance.
And what case was that?
The one involving this witness from March 23rd of this year.
Which was what charge?
The carrying concealed weapon.
Oh, right. The court's not considering that.
And Your Honor, I'm sorry to butt in, but I did not include that in my list.
The court's
of
not
cases.
considering that. Okay.
I know you're not considering it from that perspective, but I do think it's relevant as it relates to this particular witness and some bias that exists between he and the client. That's one. The domestic violence case that was then recategorized as a battery that was then ultimately null pros, which is why his bonds were, in this case, revoked.
Initially,
Yes, Your Honor. And I think there was actually another one where a warrant was sought and then ultimately quashed by the state attorney's office involved in the allegation where Ms. Burton had testified that she wanted to file a criminal complaint against an assailant at the office from last year, and they opted to pursue my client for that charge. So Mr. Dewitte is clearly capable of exercising the judgment he needs to stay out.
What about the failure to register charge?
We're litigating that, Judge. I mean, I don't understand the new one that we just got a copy of.
Well, the one that's, I don't know. There's more than one?
There's a brand new one that the one that was just served a week and a half, 2 weeks ago, Your Honor, in Osceola County.
Okay.
Is alleging a phone number that they're saying wasn't properly registered. That's the newest of the charges. So my understanding of the case that's been set for trial next week is a case involving my client's wife's vehicle, where the vehicle was known by law enforcement and it was registered, but I guess the tag was changed at some point or renewed by the DMV, and it may be that specific tag was not properly registered. It's a pretty de minimis violation. It's not the kind of case in a normal circumstance. If Mr. Dewitte was Joe Schmo and not Mr. Dewitte, I suspect that we would have a reasonable plea offer and the case would be resolved. But because Mr. Dewitte is Mr. Dewitte, that's a tougher nut to crack, so to speak, Your Honor. So that it's not a case I would normally want to try, nor would it necessarily need a trial. So that's the predicament we're in on that case. I don't know if Your Honor wants to address that case at this time or not, but counsel and I had been talking about it, and I had indicated there might be some value in continuing that case, so he and I might have a more thorough conversation about if there's a path to resolution in these cases. We have had a prior plea offer tendered by a prior prosecutor that was rejected, but there may be an opportunity for us to revisit this.
File your motion.
Yes, Your Honor.
And so Your Honor's aware, he does have his Osceola cases set for trial. I believe Judge Carson has already denied a motion to continue on that. I can tell you the state is ready on those cases.
Ooh, Judge Carson.
Just for the court's order.
Yes, that's accurate. Judge Carson did deny my last request for continuation.
Okay, is that it?
Yes, Your Honor.
Okay, the motion for bond is denied, and the reasons for that are numerous. The first being the arrests of the defendant while out on bond at least twice. And so far as this domestic violence case that was either null prost or no info or died of natural death, whatever it was, that led to a lawful arrest. It survived initial appearance scrutiny, and frankly, after hearing the 911 call and the testimony of that witness, who had little to no credibility, frankly, and the court is not prepared to say that that was some trumped-up, frivolous charge, and that 911 call was alarming, and together with the absence of credibility of that witness, and the court would base its ruling on that, and then the subsequent failure to register case. In addition to those things,
Oh, sweet victory. You can really feel the exasperation out of the judge there. You can tell she's kind of fed up with Mr. Dewitte. You know, he can only pray that he never ends up in front of her in another bond hearing or court session again. Anyhow, thank you guys so much for watching. Please like, share, comment, subscribe. Most importantly, comment below. Love to interact with you guys down there. Let me know what you're thinking. What do you think about